ನೋಟಿಸ್ ಕೊಟ್ರೆ ರಿಪ್ಲೈ ಕೊಡಲ್ಲ. ಆಯ್ತು ದರ್ಶಲ್. This matter is listed for admission. I heard the counsel for the appellant. The factual matters of the case of the plaintiff before the trial court that this appellant was tenant and he entered into an agreement dated 1/5/2019 on monthly rent of rupees 23,000. And except payment of advance, he did not pay the rent at any point of time. And also it is his case that legal notice was issued and the same was served and not given any reply. And without any other alternative, filed the suit for the relief of ejection. And court also issued notice against him, and in spite of service of notice on 25/11/21, he did not choose to appear before the court when the case was posted, and thereafter trial court proceeded to record the evidence of PW1. And PW1 court marked the document exhibit P1 to 18A. The trial court passed the ex parte decree against the appellant, and the same is challenged in RA number 22 of 2022. And the appellate court also, having considered the grounds urged in the appeal memo, formulated the point whether the trial court whether the plaintiff has proved before the trial court that he has validly terminated the tenancy of the defendant in respect of the scheduled property, and that defendant was in due for a sum of rupees 6,44,000 towards the arrears of rent, and whether he is entitled for possession, and whether judgment and decree suffers from its illegality. And also filed IA number 3 to 5 to adduce evidence. And then an application is also filed for release of the amount. And IA number 4 also considered by the appellate court, and appellate court also comes to the conclusion that in spite of service of notice, he did not choose to appear before the trial court. Even when the notice was issued, no reply was given. And also taken note of notice was served. And he did not make his appearance on 25/11/21. And hence he was placed ex parte. And also taken note of the defense of the appellant in paragraph number 26 regarding filing of OS number 3 of 1996. And all the grounds which have been urged before the appellate court also considered and confirmed the judgment of the trial court. Being agreed by the said judgment and decree of the trial court and the first appellate court against the concurrent findings, present appeal is filed. The counsel would vehemently contend that no opportunity was given and the matter may be remitted back to the consideration since he could not run the business And though possession was already been delivered, with regard to the payment of arrears of rent is concerned, matter requires adjudication. The council also would vehemently contend that appellate court committed an error in not considering the year number 3 to 5 when the relief is sought for production of additional documents. And plaintiff also not approach the court with clean hands. And he had obtained the decree by suppressing the material facts. Hence, this court has to frame the substantive question of law. Having heard the petitioner counsel and also material on record, no doubt there is a specific case of the plaintiff that this appellant is a tenant in terms of the agreement dated 1/5/2019 and monthly rent of rupees 23,000. And also the case of the plaintiff that when he had entered into an agreement, a check was given and the same was not honored, but subsequently he made the payment of rupees 1,25,000 through RTGS. And also specific case that rent was not paid from the date of occupying the premises. And trial court taking into note of rate of rent in terms of the agreement, which is marked as Exhibit P1, dated 1/5/19, arrived for a conclusion that in terms of the agreement, rate of rent is 23,000. And notice was also given in terms of Exhibit P5, dated 19/12/2019, to pay the arrears of rent. And in spite of service of notice, no reply was given. And also not made any efforts to pay the rent. No dispute with regard to the service of notice before filing the appeal. And even after the service of suit summons also, defendant did not choose to appear before the trial court and contest the matter. Now he cannot contend that no opportunity was given. And records reveals that notice was served on him on 25/11/21 itself. And judgment was pronounced in the month of January 2023. And unless he makes representation and engage the counsel, question of giving any opportunity also doesn't arise. Having considered the material also that before filing the suit, legal notice was also issued and the same was served on the appellant. And postal agreement is also marked as Exhibit P6. And he did not make any efforts to contest the matter by filing written statement. And when such being the case, the very contention that no opportunity was given and matter requires to be remanded doesn't arise. While remanding the matter also to invoke Article 41 Rule 23, there must be a sufficient reason and there must be a tribal issue. No such tribal issue is available in the case on hand. And in spite of it, in spite of service of notice, he did not file written statement and contest the matter. And in the absence of any written statement, even remanding the matter also doesn't arise. The council also would submit that the appellate court also ordered for release of the amount, and the said amount is towards the arrears of rent, and an order has been passed by allowing the year number 4. And when such material is available on record, and when the document of Exhibit P1 agreement is also placed before the third court, and in terms of the agreement, rate of rent is 23,000. And when such being the case, the calculation is also made for recovery of amount and directed to pay the rupees 7,24,500 to the plaintiff towards arrears of rent, along with 6% interest, since he did not make any payment after taking the possession. And hence I do not find any ground to interfere with findings of the trial court as well as the first appellate court, and even first appellate court also, considering the grounds urged in the appeal memo, in detail discussed each one of the contentions raised before the appellate court. And hence not a case for invoking section 100 of CPC to frame any substantive question of law, and nothing is there on record to Frame any substantive question of law. In view of the discussions made above, I pass the following order. Second appeal is dismissed.
That suit for partition Millards was
Hmm.
filed by the respondents 1 and 2 herein Millards. That was decreed. As against that Millards, ARIA was filed. Millards, what has happened is the extent of the property has been wrongly shown Millards. I have produced the title deed in REA. Millards, the extent of the property Millards is 29 into 76 Millards. But in the demarcation Millards, it is shown as 29 into 98. Extra extent ಅಲ್ಲಿ government conservancy ಬರುತ್ತೆ ಅದನ್ನ ನಮ್ಗೆ ಬಿಟ್ಕೊಟ್ಟಿದ್ದಾರೆ. That is the only grievance for which I have filed this appeal, Millards.
Whether you have appeared in FDP proceedings or
Please,
not?
Millards, I had appeared in the FDP proceedings. I have filed the objections to the commissioner's report, Millards. Despite that, Millards, my objections are not considered. And the demarcations were made, Millards. I have taken that as a main ground to this appeal, Millards.
Where is your objection statement? Conservancy is allotted to you ಅಂತ ಎಲ್ಲಿ ತಗೊಂಡಿದ್ರಿ ಅಂತ?
In the ground, Millards.
Go to paragraph number 15 of the trial court order. You have not filed any commission objections to the commissioner report.
ಮಾಡಿದ್ದೆ sir.
ಹಾಕಿಲ್ಲ ಅಂತಿದೆ ಇಲ್ಲಿ.
ಇಲ್ಲ ಹಾಕಿದ್ದೀನಿ.
Go to ink page number 54, madam.
Please.
Petitioner and respondents have not filed any objections to the commissioner report.
The petitioners filed this petition to draw the final decree in pursuance of the preliminary decree passed.
ಬೇಡ ಕೆಳಗಡೆ ಹೋಗ್ಬಿಡಿ madam, bottom.
Uh,
The civil engineer is appointed as court commissioner
Commissioner
and he filed
filed
commissioner report.
The petitioners and respondents have not filed any objection to the Millards. We have filed. I have the copy, Millards. I do have the copy. And in that, Millards, whatever portion has been granted to me, Millards, RNLE have produced this title deed. At least LCRs may be called for to show that the extent is only 29 feet into 76 feet. Whereas the commissioner has taken 29 into 98 feet, which is 22.
Already possession also taken, madam. In
ಇಲ್ಲ
terms of-
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇವಾಗ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. That is the reason I have moved the matter, Millards. The tenants who are under
ಎಲ್ಲಿದೆ commissioner report ನೀವು objection ಹಾಕಿರೋದು? ಇವನ್ ಆರ್ಯನಲ್ಲೂ ಮಾಡಿಫೈ ಮಾಡಿದಾರಲ್ಲ ಮೇಡಮ್, ನಿಮ್ ಅಪೀಲ್ ಕೂಡ ಮಾಡಿಫೈ ಮಾಡಿದಾರಲ್ಲ?
Millards. At least ನಾವು ಶೆಡ್ಯೂಲ್ ಆದ್ರೂ ನೋಡಿ ಆರ್ಯ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ the two shop premises facing north and residential premises facing east to west.
Even go to page number 30. Order passed by the appellate court. Paragraph number 19. I have thoroughly gone through the commissioner report. No doubt the commissioner has issued the prior notice to the parties and also drawn spot measure on 4/8/2019. And all the parties to the proceedings have signed the said measure. Further, it reveals that commissioner has drawn rough sketch at the spot and then he has prepared specific and accurate report and submitted to the court. The commissioner has measured the total extent of the social property and then divided into 6 shares.
Millards, I
Further, in front portion of the northern side of the social property, there is 2 shops and residential houses. 2 shops are residential building were also divided into 2 shares. And the commissioner has valued the shop building, residential building. Further, portion of number 3 is having old dilapidated building and portion 4, 5, 6 are for vacant site. Only in share number 1 and 2, there is a shop and residential building, which is valued at rupees 11,40,000 by the commissioner, divided into 2 portions, and the commissioner opined that the person gets the allotment portion number one must share the amount of rupees 1,42,000 to the remaining four sharers.
Millards may kindly go to ink page 29 of the paper book, Millards. That is the RA order. Millards, last five lines, Millards. In the said FDP, civil engineer was appointed as court commissioner, and after executing the court commissioner warrant, commissioner report was submitted before the trial court. The same was opposed by respondents 2 and 3 by filing their objection. That is us, Millards. We have filed the objections, Millards, because the government conservancy bantu anta helidre namge demarcation gu problem agutte, and it will not be for any usage, Millards. Avaru bandu aamele namge galate ಮಾಡ್ತಾರೆ. So 22 feet has been overused, Millards, by the commissioner. That's what is my only grievance. And I have also submitted before the courts below that the shops were constructed by me by investing 13 lakhs. Adina, one of the defendants also come to my aid, Millards, by adducing evidence. Avaru heltare nam brother adna kattirodu anta. But since I did not have any documentary proof of the bills or something, that has been discarded by the trial court.
Even at the time of drawing of measure, you are very much present. When the property was also measured by the commissioner, you are present.
But Millards,
all things are done in your presence only.
My objections are not taken into record. A conservancy bantu anta helidre whatever is the total extent that has been exceeded by them, Millards. That is my grievance. And now, Millards, the plaintiffs have issued the notice to my tenants to vacate the premises.
ನಿಮ್ಗೆ ಈಗ ಯಾವ್ದು ಅಲಾಟ್ ಮಾಡ್ರ ಶೇರ್ ಅದು?
ಹೌದು, ನಮ್ಗೆ ಅಲಾಟ್ ಮಾಡಿರೋದು ಅಷ್ಟೇ. ಹಿಂದೆಗಡೆ ಬರೋದು ನಮ್ಗೆ ಪೋರ್ಷನ್ 5 and 6 ನಮಗೆ. ಪೋರ್ಷನ್ 5 and 6 2 brothers ಗೆ ಬರುತ್ತೆ. ಅದ್ರಲ್ಲಿ one of the brothers ದು ವಿಡೋ ಮತ್ತೆ ಮಗ ನಾವು.
ನಿಮ್ಮ ಹೆಸರೇನು?
ಸುನೀತಾ and ಮಾಸ್ಟರ್ ಗೌರವ್.
Respond number 3A Sunita and 3B Master Gaurav are jointly allotted portion number 5.
Please.
Total area measuring 438.18 square feet as shown in the commissioner sketch.
5 and 6 alle conservancy hogodu. That is in the behind portion of the properties.
Commissioner report al torsidara conservancy na? Elli the commissioner report. ತ್ರೀ ಎ 3B ಗೆ ಇಬ್ಬರಿಗೂ ಕೂಡ ಜಾಯಿಂಟ್ ಆಗಿ ಅಲಾಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅದು ತಾಯಿ ಮಗ ಮೈನರ್ ಸನ್.
ಹೌದು. ಇಲ್ವಾ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್? Commissioner report. The counsel for the petitioner is directed to produce the commissioner report. List this matter on 28/6. 88 J Lakshmamma KB.
Divergent finding that appellate court is reversed the judgment and decree passed by the trial court. Suit is filed by the plaintiff for permanent injunction in respect of 2 acres 20 guntas in survey number 41 out of measurement of 4 acre 38 guntas. The suit is decreed in favor of the plaintiff Thereafter, my lord, the defendant has filed appeal, my lord, RA is reversed, my lord. Originally, the property is granted to the defendant by the government wide order number LND 1994-95 in the year. Out of said measurement, my lord, he has agreed to sell the property by way of agreement of sale for the year 2001 and put the possession plaintiff in the suit property to the extent of 2 acres 20 guntas. Since from 1998, he is in possession, my lord, without any obstruction. When in the year 2012, the defendant has interfered with the possession of the plaintiff. Then she has filed the suit, my lord. The defendant has denied the execution of the agreement and possession, my lord, but he has admitted that he was put the possession, permissive possession to stay the plaintiff in the constructed house, but she has constructed the house and she is cultivating the said land since from the sale of agreement, my lord. Para number 15 of the judgment, my lord, page number 63. The RA is reversed only on the ground that, my lord, yes, conditions na ಅದು violate ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು granted land na conditions na violate ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು only on that ground reversed the judgment, my lord. But in the agreement itself, exhibit P1 is the agreement of sale. Agreement alle ತೋರಿಸಿದ್ದಾರೆ after completion of the condition period, he will execute the registered sale deed ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳಿದ್ದಾರೆ. But thereafter, my lord, she has filed appeal before the assistant commissioner for regularization. That has been dismissed. Against which, my lord, the defendant has filed appeal before the deputy commissioner. The deputy commissioner has confirmed the order of the assistant commissioner holding that he has violated the conditions. In respect of possession, my lord, nowhere stated anything about the possession, my lord. Against which, my lord, the defendant has challenged the said order by filing appeal before the Karnataka Land Tribunal, Karnataka Appellate Tribunal in appeal number 278 of 16. The same was dismissed for non-prosecution on 9/10/2017. And the same was restored on 10/6/2020. The appeal is still pending consideration. In the meantime, my lord, she has filed form number 57 for regularization of her property in respect of her property. The ADLR has draw the measure and prepare the sketch regarding she is in possession of the property in respect of measuring 2 acres 20 guntas. As per exhibit P20, 21 and 22. I have produced the same documents were produced before the trial court, my lord. In respect of possession, my lord, till today, nobody is interfered, my lord. Against the cancellation order, my lord, the appeal is still pending before the Karnataka Appellate Tribunal. Appeal number 278 of 2016.
Issue notice, call for records.
Yes.
This case of the plea for appellant. The plaintiff filed a suit for declaration before the trial court. A suit is dismissed. In this case, Lord, the plaintiff purchased the plaint A schedule property from one Mr. Ibrahim. That Ibrahim, that defendant number 2, is not the owner of the schedule property. So he has colluded with the defendant number 1. He sold the plaint A schedule property in favor of defendant number without the consent knowledge of the plaintiff. The dispute is only, my lordship, 10 into 3, 30 square feet. That total measurement is, my lordship, that 110 square feet and another one is 30 square feet. Soon after purchase of the social property, the plaintiff has bifurcated into 2 parts. One is 110 square feet, another one is 10 into 3 square feet. My lordship. The trial court framed the issues. Kindly see the page number 54, my lordship. 54. Based on the above pleadings, this court framed following issues. Whether the plaintiff proves its title over the schedule property as alleged. The answer is, my lordship, affirmative. Kindly come to the page number 55, not. The reasons, the defendant number 1 himself stated that in the last para, my lordship.
ಆಯ್ತ್ರಿ ನಿಮ್ಗೆ ಈ ಪ್ರಾಪರ್ಟಿ ಹೇಗ್ ಬಂತ್ರಿ?
I have purchased the social property under the registered sale deed, my lordship.
ಯಾವಾಗ ಅದು?
In 15/6/2013, my lordship.
15/6/2031.
I will tell the exact date. On 31/5/2020, by a registered sale deed at sub-registrar office, Sulya, my lordship. That is Annexure C. Lordship. The defendant number 2 is no way concerned in the with respect to the schedule property. By colluding with the defendant number 1, he sold the plaint A schedule property in favor of the defendant number 1. So therefore, we have filed a suit for declaration as against the defendant number 1 and 2 before the trial court. In fact, the defendant number 1 himself stated that he is not disputed the title. It has framed in the issue number 1, my lordship. Kindly come to the page number that 56, my lordship. He has stated specifically, he has stated that the defendant pleaded just ignorance about the plaintiff title. He has not denied specifically with regard to the title of the plaintiff. Therefore, I answer this issue number 1 is affirmative. The dispute is only with regard to the 10 into 3, 30 square feet, which is very much adjacent to the another plaint A schedule property, that 110 square feet. For the convenience sake, he has bifurcated into 2 parts. The first one is that 110 square feet, that next shop is 30 square feet. As per the registered document, he is the absolute owner of the schedule property. And defendant number 1, that falsely stated, that wrongly stated in his written statement. The defendant number 1 was demanding and pressurizing the plaintiff to sell that 30 square feet area to him, and the same was refused by the plaintiff. When plaintiff is the absolute owner of the schedule property, the question of demanding by the defendant number 1 that does not arise. He never demanded and pressurizing plaintiff to sell that remaining portion of the 30 square feet. Just he has deliberately taken the contentions in his written statement, my lordship. The southern portion of the shoot property was covered by two selling shutters. One is for 11 into 10, 110 square feet. That next area, another rolling shutters is for 10 into 3, 30 square feet. Which is pertaining to the,
You go to your admission counsel in paragraph number 20 of the appellate court order. And so also in paragraph number 16,
years.
go to ink page number 35. On perusal of the cross examination of PW1, he stated that ದಿನಾಂಕ 11/3/2000 ಪ್ರತಿವಾದಿಯು ಬಲಾತ್ಕಾರವಾಗಿ ದಾವಾ ಅಂಗಡಿಯನ್ನು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಎಷ್ಟು ಸಮಯದಲ್ಲಿ ಎಷ್ಟು ಹೊತ್ತಿಗೆ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ ಎಂದು ನೆನಪಿಲ್ಲ. ಪ್ರತಿವಾದಿ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವಾಗ ನಾಗರಾಜ ಎಂಬುವರು ಅಂಗಡಿಯಲ್ಲಿ ಹಾಜರಿದ್ದರು. ಸದರಿ ನಾಗರಾಜರವರು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವ ಸಮಯದಲ್ಲಿ ಯಾವುದೇ ತಡೆ ಮಾಡಿರುವುದಿಲ್ಲ. These are the admissions given by him. ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಆಸ್ತಿಯನ್ನು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವಾಗ ನಾಗರಾಜರವರು ನಿಮಗೆ ತಿಳಿಸುತ್ತಾರೆ ಎಂಬ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿ ಆತನಿಗೆ ಗೊತ್ತಾಗುವುದಿಲ್ಲವೆಂದು ನುಡಿದಿರುತ್ತಾರೆ. These are the answers given by you. ಬಲಾತ್ಕಾರವಾಗಿ ಯಾರು ಸ್ವಾಧೀನ ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. These are the admission from the mouth of PW1. ನಾನು ಶಾಫಿಯಾಗಿ BM ಉಮರ್ ಅವರ ಬಳಿ ಕೇಳಿದಾಗ ಅವ್ರ ಮಾತುಕತೆಯಲ್ಲಿ ಮುಗಿಸುವ ಎಂದು ಹೇಳಿರುತ್ತಾರೆ, ಅಷ್ಟೇ ಹೇಳಿರೋದು.
No, Lord, see, what has happened that by oversight he has admitted that. But under the.
Even in page 20 also, in this cross examination stated that 140 ಚದರ ಅಡಿ ಜಾಗ ನನಗೆ ಬರಬೇಕೆಂದು ದಾವೆ ಹೂಡಿದ್ದೇನೆ. ನಾನು ದಾವಾ ಆಸ್ತಿಯನ್ನು ಇಬ್ರಾಹಿಂ ಅವರ ಕಡೆಯಿಂದ ಖರೀದಿ ಮಾಡಿದ್ದೇನೆ. ಸದರಿ ದಾವಾ ಆಸ್ತಿ ಖರೀದಿ ಮಾಡುವಾಗ ಅಳತೆ ಮಾಡಿದ್ದೆ. ಅದು 140 ಅಡಿ ಜಾಗ ಇತ್ತು. ದಿನಾಂಕ 31/5/2001 ಸದರಿ ಜಾಗವನ್ನು ಖರೀದಿಸುತ್ತೇನೆ. ದಾವಾ ಆಸ್ತಿ ಖರೀದಿಸುವ ಮುನ್ನ ರಾಜಧಾನಿ ಜ್ಯುವೆಲರೀಸ್ ಎಂಬುವವರು ಬಾಡಿಗೆಗೆ ಇದ್ದರು. ಅಬ್ದುಲ್ ಲತೀಫ್ ಎಂಬುವರು ನಾನು ಬರುವ ಎಷ್ಟು ವರ್ಷಗಳಿಂದ ನನ್ನ ಅಂಗಡಿ ಪಕ್ಕ ಇದ್ದಾರೆ ಎಂದು ಗೊಳ್ಳಲಾಗುವುದಿಲ್ಲ. ನಾನು ಅಂಗಡಿ ಖರೀದಿಸುವಾಗ ಇತ್ತು, ಅಂಗಡಿ ಹೆಸರು ನೆನಪು ಇಲ್ಲ. These are the admissions given by PW1.
Yes, sir.
What is the error in the order?
So under the registered sale deed document, so he is the absolute owner of the shoot.
Maybe.
Prior to purchase of the shoot property, the defendant number was already in possession under the rental agreement.
ಹೌದು.
But there was no rental agreement. That is the reason we could not able to produce it before the trial court.
Defendant number 2 executed sale deed in favor of defendant number 1.
Yes, that by pleading with the defendant number 1, he is no way concerned. He is not the owner of the.
And also your case is that forcibly taken the possession. That has also not been proved.
No, he is that defendant number 2 is no way concerned to the title that schedule A property.
I agree, but-
Property.
Ah.
That deliberately by colluding with the defendant number 1, he executed the sale deed in favor of defendant number 1. That is with respect to the.
You are not in possession.
Yes.
Second thing is you have not proved the
What has happened?
dispossession.
Yes,
nothing.
prior to purchase of the shoot schedule A property, then that defendant number 1 is in the possession.
Your case is
As a tenant,
encroached ಅಂತ,
As
but
a tenant.
encroached ಗೆ ಏನು answer ಇಲ್ವಲ್ಲ?
as a tenant.
So this matter is listed for admission and I heard the counsel for the appellant. This second appeal is filed against the concurrent finding of trial court as well as the first appellate court. The factual matters of case of the plaintiff before the trial court that he is the owner in possession over the social property.
And the issue notice now.
ಏನಕ್ಕೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಹೇಳಿ?
Because that, no.
ಅವ್ನ ಯಾಕೆ ಬಂದು ಇನ್ನೊಂದ್ಸಲ
I have-
ಲಾಯರ್
no,
ನೆಟ್ಕೊಂಡು
I have
fees ಕೊಡ್ಬೇಕು?
I have produced the registered sale deed document. before the
ಇರ್ಬೋದು.
trial. I have produced the registered sale deed document before the trial court. Not.
ಹ್ಮ್.
Like we have a good case. Not. Let the trial, let the LCR come. Not. Let the LCR come. The dispute is only with regard to the, that 10 into 3, that measuring 30 square feet. Not.
Yes.
We are the. No,
Encroachment has not been proved
no, that,
and disposition has not been proved.
that,
ಹೌದು, ಏನಾಯ್ತು ಮೇಡಮ್?
kindly issue emergent notice, my lordship.
Notice ಕೊಡೋದಿಲ್ಲ. Not a case for issuing of notice.
Lord,
Why he has to come and engage the counsel in high court? High court ಅಲ್ಲಿ ಬಂದು ಲಾಯರ್ ಇಟ್ಕೋಬೇಕಾದ್ರೆ ಎಷ್ಟು ಫೀಸ್ ಕೇಳ್ತಾರೆ ಗೊತ್ತಾ ನಿಮ್ಗೆ? ಹೇಳಿ, ಕೇಸ್ ಇದ್ರೆ ಕೊಡೋಣ.
ಅಲ್ಲ, there is a
ಕೇಸ್
case
ಇಂದವ್ರು ಯಾಕೆ ಕೊಡ್ಬೇಕು?
that we have produced the registered document
no,
before the
counsel.
trial court. That, no. Insofar as that encroachment is concerned, that by oversight he has said not to kindly.
Evidence, your evidence has been relied upon by both the courts.
No,
You
trial
have
court has come
admitted.
to, trial court has come to the conclusion only on the ground that he has not admitted the possession. That's all, my lord.
No, yes.
Yes. Kindly issue LCR, my lord.
No.
Kindly call for the records. My lord.
Records no ಅವಶ್ಯಕತೆ ಇಲ್ಲ. Answers what have been given, that has been extracted in the order of the trial court in paragraph number 17.
Depending on only.
17 is very clear.
For the
Not
sake.
only that, even first appellate court also extracted
Like we have
the
pleaded, we have.
admission given by you in paragraph number 19 and 20, 16 and 20.
No, prior to purchase of the fruit scheduled property, the defined number one was a tenant in the, with respect to the 30 square feet, my lordship. He was in possession, but there was no rental agreement between that earlier owner and defined number one. So therefore, he could not able to produce, my lord. Please, my lord.
ಏನಾಯ್ತು ಮೇಡಮ್?
That LCR is required, my lord.
ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
Please.
ಎಲ್ಲ ಆನ್ಸರ್ಸ್ ಏನೇನ್ ನೀವು ಕೊಟ್ಟಿದ್ದೀರಿ ಅದೆಲ್ಲ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
No, but the defined.
ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲೇ ಇದೆ ರೀ ಎಲ್ಲದನ್ನು.
Because defined number one has not denied about the title dispute. Title dispute ಮಾಡಿಲ್ಲ ಅವರು.
ನಿಮ್ ಕೇಸ್ ಏನು ನೀವು ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ. ದಟ್ ಈಸ್ ದ ಅಡ್ಮಿಷನ್.
No, what by.
ನಿಮ್ ಕೇಸ್ ಏನು ಹೇಳಿ.
In case that we are the absolute owner
ಹ್ಮ್
purchased from the one Mr. Ibrahim,
ಹೌದು
not from the defined number two.
ಆಯ್ತು.
So that defined number two is no way concerned to the defined number one
ಹ್ಮ್
and the plaintiff.
ಹ್ಮ್
So without having any title document, he sold the very same scheduled property in favor of defined number one.
ಹ್ಮ್
So that sale deed itself is illegal,
ಹ್ಮ್
not binding on me.
Hmm.
So that is our
ಆಯ್ತು. ನೀವು
pleading.
ಪರ್ಚೇಸ್ ಮಾಡೋಕೆ ಯಾರು ಇದ್ರು ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಪೊಸಿಷನ್ ಅಲ್ಲಿ?
Possession. No, in one portion I was in possession.
ಹ್ಮ್
So when I was in possession,
Hmm.
I was also tenant.
ಹ್ಮ್
Under the rental agreement. So that defined number one was also tenant.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲಲ್ಲ ಮೇಡಮ್?
ಇಲ್ಲ ಬಂದಿಲ್ಲ sir.
ರೆಕಾರ್ಡ್ಸ್ ಬರಲಿ ಅಷ್ಟೇ, ನೋಟಿಸ್ ಮಾಡಿರೋದಿಲ್ಲ.
ಅಲ್ಲ,
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್.
ಅಲ್ಲ, till that.
This matter,
No,
no
I
such
first
order.
say,
No such order.
ಅಲ್ಲ, let him not alienate the.
No, you.
ಅಲ್ಲ,
First of all, your RSA
Yes,
is
yes.
not maintainable.
very sorry. ಅಲ್ಲ, what has happened? There are every chances to alienate the scheduled property.
Issue
in favor of
notice,
third party.
the
State
registry is directed to call for records. List this matter on. Madam. 11/7.
Directed both the parties to maintain status.
7/7, that's all.
Otherwise,
That's
there are
all.
every chances to alienate the scheduled property. in
Nothing
favor
will
of-
happen, counsel.
ಅಲ್ಲ, ಆಗುತ್ತೆ.
First of all, you are not in possession.
ಅಲ್ಲ, in case
Ah.
if property,
If you succeed, then we will see.
property ಮಾರಾಟ ಮಾಡಿದ್ರೆ, then I will be deprived from the rights.
That's all. Next,
Status,
state number 90.
not.
Hmm.
That's it. I got the reliable information.
Hmm.
There are every chances to alienate the scheduled property. in
Yeah,
favor of-
nothing will happen. If you succeed, you would get the order. You would get the possession, that's all.
ಮಾರಾಟ ಮಾಡಿದ್ರೆ ನನಗೆ ಅಲ್ಲಿ ಮತ್ತೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ.
No case for,
Status.
no case for interim order. Even call for records ಮಾಡಿದ್ದೇನೆ, only you have to look into the evidence ಅಷ್ಟೇ. ಹೇಳ್ರಿ. ಕೊಡೋದಿಲ್ಲ ಅಂದ್ರೆ ಎಷ್ಟು ಹೇಳೋದು ನಿಮಗೆ? ಒಂದ್ಸರಿ ಹೇಳಿದ್ರೆ ಅರ್ಥ ಆಗೋದಿಲ್ಲ. ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಲಾ? ರೈಟ್ ನಾವು ಐ ವಿಲ್ ಡಿಕ್ಟೇಟ್ ದಿ ಆರ್ಡರ್. ಹಾ, ಕೇಸ್ ಇದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ, ನೀವು ಕೇಳೋದೇ ಬೇಕಾಗಿಲ್ಲ ರಿಲೀಫ್ ನ.
ಒಂದು ವೇಳೆ ಮಾರಾಟ ಮಾಡಿದ್ರೆ ಮತ್ತೆ
ನಥಿಂಗ್ ವಿಲ್ ಹ್ಯಾಪನ್. ಬನ್ರಿ ಸುದೇಶ್ ಕುಮಾರ್ ಆಚಾರ್ಯ. ಪಾರ್ಟ್ಲಿ ಡಿಕ್ರೇಟ್ ಟು ವೆಕೇಟ್ ವಿತ್ ಇನ್ 1 month. 500 rupees ರೆಂಟ್ ಕನ್ಫರ್ಮ್. ಹೇಳಿ ಏನು?
appearing for the tenant.
ಹ್ಮ್
It's a suit for possession.
ಡಿವೇಟರ್ ಇದ್ದೀರಾ? ಆಯ್ತು ಹೇಳಿ.
My lord, a suit for possession
ಹ್ಮ್
brought on the basis of title.
ಹ್ಮ್
Now the plaintiff contends, my lord,
ಹ್ಮ್
that he had purchased the property
ಹ್ಮ್
on 7/1/2004,
7/7.
7/7/2004.
ಹ್ಮ್
The defendant was occupying the building
ಹ್ಮ್
as a licensee under his vendor.
ಹ್ಮ್
And thereafter, on the very same day, he issues a notice terminating the license
ಹ್ಮ್
and brings the suit for possession
ಹ್ಮ್
on the strength of his title.
ಹ್ಮ್
Now, what the, if your lordship peruses the plain government,
ಹ್ಮ್
I am permitted to. Now, the para 4 nalli,
ಹ್ಮ್
The plaintiff averts that last paragraph 4, last 2 lines. The defendant in his reply, notice, denied the license and set up the contention that the suit room does not exist within the property purchased by the plaintiffs. This is one of the contention. And para 6 it is further submitted that the defendant with some ulterior motive to gain unlawful, purposefully denied the title of the plaintiff. These are the two contentions that are raised by the defendant even before the suit. One is the plaintiff has no title. Second is the property that is purchased by the plaintiff.
Your reply is not title, denying the title.
Allah.
Only saying that this premises not comes within the property purchased by the plaintiff.
Para 6. It is further submitted that the defendant with ulterior motive and to gain unlawful purposefully denied the title of the plaintiff. Therefore, there are two contentions that are raised by the defendant. One is that the plaintiff is not the owner. Second is the property purchased by the plaintiff does not include the suit.
Yes.
Suit process. Now, if your lordship peruses the plaint, in the description of the property, no boundaries are. Now, in a suit for possession or in respect of an immovable property, Order 7 Rule 3 prescribes that the property should be described with reference to boundaries. When the defendant takes up a specific contention that the property purchased by the plaintiff does not include the suit building, the plaintiff should have given the boundaries. That is not there. Second is, in a suit for possession, the plaintiff should succeed on the strength of his own case. Now, I have contended that the suit property does not include, the sale deed does not include the property which is the subject matter of the suit.
Yes.
Now, a commission is taken in this case. Commissioner was appointed and he has reported that he is not in a position to identify the property and he cannot say as to whether the suit property is located within the property purchased by the plaintiff. The courts below expect the defendant to prove the contention that the suit property is not within the property purchased by the plaintiff. That is what the First Appellate Court and the trial court have committed the mistake. Your lordship may kindly permit me to refer to the
cross examination ನೋಡಿ ಪೇಜ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಪ್ರತಿವಾದಿಯರು ನಡೆಸುತ್ತಿರುವ ಅಂಗಡಿ ಪ್ರತ್ಯೇಕವಾಗಿ ಇರುತ್ತದೆ ಮತ್ತು ದಾವೆಯಲ್ಲಿ ಹೇಳಿದಂತಹ ಯಾವುದೇ ಕಟ್ಟಡಕ್ಕೂ ತಾಗಿಕೊಂಡು ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. This is the admission. Page number 4 of cross of PW1. PW1 cross ಅಲ್ಲಿ cross examination starts at page number 3. Chief ಎಲ್ಲ ಆದ್ಮೇಲೆ cross ಆದ್ಮೇಲೆ come to page number 4. ನಿಮ್ದೆ cross examination admit ಮಾಡಿರೋದು. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 5 ಅಲ್ಲಿ ಕೊನೆಯಲ್ಲಿ 6 ಲೈನ್ಸ್ 3, 4, 5, 6 6th ಲೈನ್ ಕಮೆಂಟ್ಸ್ ಆಗುತ್ತೆ ನೋಡಿ. ಅಲ್ಲಿ ಪ್ರತಿವಾದಿಯು ನಡೆಸುತ್ತ ಹೌದು ಎಂದರೆ ಸರಿ. ಅಡ್ಜಸೆಂಟ್ ಇಲ್ಲ ಅಂತ, ಅದಕ್ಕೆ ಅಡ್ಜೈನಿಂಗ್ ಇಲ್ಲ ಅಂತ. ಹೌದು, ದಾವೆಯಲ್ಲಿ ಹೇಳಿದಂತಹ ಯಾವುದೇ ಕಟ್ಟಡಕ್ಕೂ ತಾಗಿಕೊಂಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಸರಿ. ದಟ್ ಮೀನ್ಸ್ ದಟ್ ಈಸ್ ಇನ್ ಶಾಪ್ ಆಫ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಶಾಪ್ ಅಂತ. ಹೌದು, ಸಪರೇಟ್ ಆಗಿದೆ ಅಂತ. ಹೌದು, ಸರಿ. ಹೌದು. ಸರಿ, ಹಾ. Hmm. Reply given by them. ಹಾ. ರಿಪ್ಲೈ ಇದೆಯಾ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಯಾ ಅಲ್ಲಿ? ಹಾ, ಹೇಳಿ ಏನಂತ ಹೇಳ್ತಾನೆ.
Further instructs me to state that my client has been a licensee
ಹಾ,
under the vendor of your client
ಹಾ,
in respect of the scheduled purchases shown in the notice
ಹ್ಮ್,
before the same is purchased by the client. Therefore,
ಹ್ಮ್.
like my vendor.
That is the reply given by him.
Yes,
Hmm.
that is referred.
Exhibit P7. Hmm. Now how you can dispute that?
That is why we have the reply of the 1980 by Supreme Court.
This reply takes your case. My client further instructs me to state that my client had been a licensee under the vendor of your clients in respect of the scheduled premises shown in the notice under reply before the same is purchased by your client. This is a clear admission. Then you have no case at all.
One submission.
Here.
Blood, one submission.
Hmm.
I am referring to this judgment of the honorable. I am referring to this.
Hmm.
1 minute. One minute. It means,
Hmm.
then they have to surrender the possession. Then claim. That is a different case, my lord, where the tenant purchased the right of the.
Whatever it may be,
owner.
counsel, now you cannot dispute that
One
you are
minute,
not a
1 minute.
licensee under the vendor of the plaintiff. Clear admission is there.
My lord,
What do you say with regard to exhibit P7?
yes,
There is a clear admission.
my lord, regarding admission, I.
Now you cannot
I'll-
blow
I'll
hot and
point
cold
out.
that you are not a
point
licensee under the vendor of the plaintiff.
My lord,
And also premises is not comes within the
2014,
purview of the sale deed.
2014,
ಹೇಳಿ.
volume 2,
Hmm.
Supreme Court cases, page 269,
ಕೊಡಿ ಎಲ್ಲಿದೆ?
para 89,
2014
14,
ಅಲ್ಲ 2010 ನೀವು ಕೊಟ್ಟಿರೋದು.
ಅಲ್ಲ, ಈ 2014. ಅದರಲ್ಲಿ
ಹ್ಮ್.
Lord, paragraph 18.
Even you have not gone to the suggestion that ಈ ವಿವಾದಿತ ಅಂಗಡಿ ಕಟ್ಟಡ ಜಾಗ ಸರ್ಕಾರಿ ಜಾಗದಲ್ಲಿ ಇದ್ದು ಸದರಿ ಜಾಗ ವಾದಿಯವರಿಗಾಗ್ಲಿ ಅದನ್ನು ಮಾರಾಟ ಮಾಡಿದವರಿಗಾಗ್ಲಿ ಯಾವುದೇ ಹಕ್ಕು ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. This is the suggestion.
ಹೌದು.
You makes the suggestion.
ಹೌದು.
ಮತ್ತೆ ಇಲ್ಲಿ admission ನೋಡ್ರಿ ಈಗಿದೆ ಮತ್ತೆ you make such suggestion.
Lord, para 19 of the judgment matter.
ಹೇಳಿ ಏನು?
2014, volume 2, 269,
Hmm.
volume, para 19.
ಯಾರ?
19.
19.
The legal position therefore is clear that the plaintiff in a suit for declaration of title and possession would succeed only on the strength of his own title, and that could be done only by adducing sufficient evidence to discharge onus on it, irrespective of the question whether the defendants have proved their case or not. We are of the view that even if the title set up by the defendants is found against them, in the absence of establishment of the plaintiff's own title, the plaintiff must be non-suited. This is what I am bringing to your
It is settled
kind
law.
attention. Now,
Settled law also.
pardon,
This is settled law.
how?
He has to prove his case on
Yes.
his strength,
And
not on the
irrespective
weakness.
of my case,
Not on the weakness.
irrespective of what
Hmm.
I am able to
ಈ
prove or what I have.
exhibit P7 ನಿಮ್ಮ ಏನು
ಹೌದು.
admission ಇದೆ, it takes over your case. Now you cannot contend that he is not the owner of the premises. Your
My lord,
admission is clear. He was a licensee.
ಅಲ್ಲ,
That's
it-
all.
it has to be read.
Your claim is only
ಅಲ್ಲಲ್ಲ, ಒಂದು
licensee.
ಇದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ
ಹ್ಮ್.
ಪ್ಯಾರಾ ಎಕ್ಸಿಬಿಟ್ P7 ನಲ್ಲಿ
ಆಯ್ತು.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್
ಹೇಳಿ.
paragraph 3.
Hmm.
My client further instructs me to state that at no point of time he was a licensee under the vendor of your client in respect of the said premises.
Hmm.
Therefore, the admission, my lord, it is not an absolute admission. There are two contentions that are advanced by the defendant. It is not an admission which is clear. And we have contended that the shop is not within the property which is purchased by the plaintiff.
Yes.
Now, under these circumstances, the plaintiff has to succeed on the strength of his own case. He has not shown that the property is within the description of the property which is purchased under the sale deed. The commissioner is not in a position to identify the suit property. He says that I cannot say. That is para 14 of the judgment of the trial court. Para 14 of the judgment of the trial court. Since the defendant has specifically contended, page 54. Since the defendant has specifically contended that the suit schedule property exists in a government land and the plaintiffs have disputed the same, a commission was issued. The commissioner has filed his report stating that he could not measure the suit premises and other properties of the plaintiff since there was no plotting and the surveyor was not able to identify the boundary marks. Since the surveyor has not measured the plaintiff's property, the commissioner has not able to identify the exact location of the suit premises. Therefore, he could not be able to give the opinion whether the suit schedule property comes within the property of the plaintiffs or not. This is what the commissioner says. The first appellate court, your lordship may kindly permit me to refer to first appellate court's statement, which is at the page 13, internal page 13. Last few lines. Last from the bottom. It is the defendant who has contended the property.
Paragraph number?
Paragraph number 14. Page 30.
Appellate court.
Appellate court. Page 30. Last from the bottom 3 lines. It is the defendant who has contended that his property bearing number so and so exists outside the plaintiff's property. As such, he has to prove the said contention. It is for the plaintiff to show that the suit property is within his property. He has come to the court and the burden of proof lies on the plaintiff and he has to succeed on the strength of his own case. Irrespective of my case, whatever I have pleaded or not, the plaintiff has to succeed on the strength of his own case. Even in 2010 in Supreme Court, which I have cited, paragraph.
Yes.
Lord, 23. No doubt it is true that the failure to prove the defense does not amount to an admission, nor does it reverse or discharge the burden of proof of the plaintiff, but still the duty cast on the defendant has to be discharged by adducing evidence. The plaintiff has not stepped into the witness box.
Yes.
GP has been examined.
Yes.
Therefore, my respectful submission is that the plaintiff has failed to show to the court that the suit property that is the property that is purchased by him includes the suit property. Title suit, yes.
Suit is for title suit?
Based on title.
Based on title, whether relief is sought for declaration of title.
Declaration of title is implied in a suit for possession. ಅಲ್ಲ ಅವರೇ ಹೇಳ್ತಾರೆ ಇಟ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ಟೈಟಲ್ ಅಂತ ಹೇಳಿ.
ಆಯ್ತು ಅವ್ರು ಹೇಳಿ ನೀವು ಆಮೇಲೆ ಹೇಳಿದಂತೆ ಮಾಡಿಲ್ಲ.
Second part, after the termination of the license is under a clear obligation to surrender its position to the owner and it is used. We do not see the benefit by way of mandating that is positive. My lord, this judgment is referred to and followed by the judgment in Ayodhya, 99 Karnataka. And we now go to individual. That second part. By reading section 116 of the Indian Act, it is clear that the respondents having entered the tenancy under a contract and recognizing conditional contract are clearly disqualified from denying its right to the power. It's a landlord is not established this right to the lease process. Respondent will continue to operate the institution. Once the landlord's right to that. Then they refer to unqualified space. And finally, they come to page 30. Page 30. Educating this case and responding for the putting on the when he's granted by a person claiming to be home, and when a person takes control of the property, there's a necessity on it. It is no difference to the home to say that he is not aware of the of such a person position, and the cost of that the only remedy of such a person is first surrender to surrender to the person from whom he got it, and thereafter make a great whatsoever either against the person or against the property. As long as the continuance of enjoys concept of property and environment in the context of these or rights, his status continuing only as in this. First they have to surrender, then they extend surrender the second.
Yes.
Lord. Para 6 of the plate, clearly plaintiff says that there is denial of title. Para 4 ಅಲ್ಲಿ, plaintiff says that the defendant has contended that the property which he claims is not within the sale deed he has purchased.
Yes.
Now plaintiff at para 7 says he is also seeking for this relief of possession on the strength of his title. Therefore, under these circumstances, when the plaintiff himself makes an averment that his title is denied, the identity of the property is disputed, and he contends that he brings the suit for possession on the basis of title,
Yes.
whether he could have maintained the suit without seeking the relief of declaration regarding his title. A title cannot be proved by admission. Your lordship is very well aware.
I have
There-
delivered the judgment
66 Supreme Court.
last week.
Yes, my lord.
I have also delivered the
ಹೌದು
judgment.
ನೀವು ತಾವು ಮಾಡಿದ್ದೀರಿ ಅದನ್ನು.
On admission cannot be granted
ಹೌದು.
decree of declaration.
Declaration or title cannot be proved by admission.
Yes.
Now, in the instant case,
Hmm.
the plaintiff relies upon the so-called admission that is made in exhibit P7. An admission to rely on an admission, my lord, it should be clear, it should be unambiguous. Now, in the later paragraph, the defendant has denied. The very contention which is taken in the paragraph 3 has been denied. Therefore, it is an ambiguous statement that is made by the defendant, and it can always be explained. Therefore, it cannot be construed as an admission at all.
Yes.
Now, there is no proof to show that the property which is claimed is within the suit property. Therefore, commissioner does not report that it is within his property.
Yes.
Therefore, the plaintiff has failed in the suit is my response.
Third. This matter is listed for admission. I heard the counsel for the appellant and also the counsel for the respondent. The factual matters of case of the plaintiff before the trial court is that yes, the plaintiffs have jointly purchased the suit schedule property that is shop room along with the immovable properties bearing survey number 16/33 measuring 0.29.25 acres situated at Marpadi village as per registered sale deed dated 7/7/2014. And also it is the case of the plaintiff that the defendant had been a licensee under the plaintiff's vendor in respect of the suit shop room. And immediately he had purchased the property, he has terminated the license by giving notice on 7/7/2014. And the defendant did not vacate the premises. And hence he has claimed the mean profits at the rate of rupees 2,000 per month from the date of termination of license. The defendant, in pursuance of the suit summons, appeared and filed the written statement contending that the plaintiffs are not the owners of the plaint A scheduled premises, and they have no right to terminate the license. The defendant is not the licensee under the vendor of the plaintiff in respect of suit scheduled premises. The vendor has no right to transfer the suit scheduled premises in favor of the plaintiffs. The suit scheduled premises exists in the government land. Therefore, no cause of action arises for filing of this suit. And hence, suit requires to be dismissed. The trial court, having considered pleadings of the parties formulated, uh, pleadings of the parties, framed the issues and allowed the parties to lead the evidence. The plaintiff, in order to substantiate plaintiffs, in order to substantiate their case, examined the power of attorney holder, one Sri Kishore Fernandez, as PW1, and got marked the document exhibit P1 to P13. On the other hand, defendant examined himself as DW1 and got marked the document exhibit D1 to D7. The trial court, having considered both oral and documentary evidence, answered the point as affirmative that the plaintiff has purchased the plaintiffs have purchased the property, that is suit shop room along with immovable properties bearing survey number 16/33 in terms of the sale deed, and also comes to the conclusion that defendant is a licensee under the vendor of the plaintiff, and also the license has been terminated by issuing the notice. And ordered only for mean profits of rupees 500, not as claimed by the plaintiff as rupees 2,000 per month. The said judgment and decree has been challenged in RA number 4 of 2023. And appellate counsel, on considering the grounds urged in the appeal memo and also considering the material on record, formulated the point whether the trial court committed an error in directing the defendant to vacate the plaint A scheduled premises, and whether the trial court erred in directing the defendant to pay mean profits at rupees 500 per month. And the points which have been formulated by the appellants are answered in negative and confirm the judgment of the trial court. Being agreed by the said judgment and decree of the concurrent finding, the present second appeal is filed. The counsel appearing for the appellant would vehemently contend that the very approach of both the courts are erroneous. The counsel referring the plaint, particularly paragraph number 4, brought to the notice of this court that the defendant, that the plaintiff has pleaded in para 4 himself that defendant in his reply notice denied the license and set up a contention that the suit shop room does not exist within the property purchased by the plaintiff. The counsel also brought to the notice of this court paragraph number 6, wherein specific government is made in the plaint that the defendant, with some ulterior motive and to gain unlawful, purposefully denied the title of the plaintiffs. The defendant liable to surrender the possession of the suit premises on the basis of the title also, if he pleas of license fails. The defendant has denied and not ready to vacate the suit shop premises and to surrender the vacant possession of the suit shop property, and hence suit is filed by issuing the legal notice terminating the license on 7/7/2014. Based on the sale deed dated 7/7/2014, and when the license was terminated on 22/7/2014, when the defendant was called upon to deliver the possession. The counsel also vehemently contend that when the plaintiff fails to prove the very premises is in existence within the sale deed which this is civil deed under which he had purchased the property. And the title is also disputed. There cannot be any order of direction to hand over the possession of the property. The counsel, in support of his argument, he relied upon judgment reported in 2010 within bracket 4 Supreme Court cases 491. And brought to notice of this court paragraph number 23, wherein an observation is made that failure to prove the defense does not amount to an admission, nor does it reverse or discharge the burden of proof of the plaintiff, but still the duty cast on the defendants has to discharge by adducing oral evidence, which the appellants have miserably failed to do so. The counsel also relied upon the judgment reported in 2014 within bracket 2 Supreme Court cases 269 and brought to notice of this court paragraph number 19. The legal position is clear that plaintiff in a suit for declaration of title and possession could succeed only on the strength of its own title, and that could be done only by adducing sufficient evidence to discharge the onus on it, irrespective of the question whether defendants have proved their case or not. The counsel, referring these two judgments, would vehemently contend that unless the plaintiff prove his title to the suited property, cannot seek for possession, and both the courts have lost the sight of the material and record. No such proof is placed before the court in order to prove the title, and hence ought not to have granted the relief as sought. Per contra, the counsel appearing for the respondent would vehemently
Report of the commissioner does not show.
The counsel for the appellant also brought to notice of this court the discussion made by the court with regard to the commissioner report. And commissioner was unable to identify the property in view of no survey was done. And hence very identity of the property is also not been proved, even considering the report of the commissioner. And hence there cannot be any order of directing to hand over the possession. Per contra, the counsel appearing for the respondent in his argument would vehemently contend that the judgments which have been relied upon by the appellant are not applicable to the facts of the case on hand, and suit is not filed in relief of declaration, and suit is only filed for the recovery of possession on the ground that the defendant is a licensee. And also counsel not disputes the principles laid down in the judgments and contend that in a case of seeking the relief of declaration of title, then the law is settled that he has to prove the title, and hence the said judgments will not come into the aid of the appellant. The counsel also brought to notice of this court when the property was purchased, a notice was issued on the date of purchase itself. And this defendant has given reply through his advocate on 37/2014 and brought to notice of this court that an unequivocal admission made by the defendant himself in the reply that the counsel who gave the reply, while giving the reply, he categorically stated that his client further instructs him to state that his client had been a licensee under the vendor of your client in respect of the scheduled premises shown in the notice under reply, before the same is purchased by your clients. The said admission takes away the case of the defendant, and now defendant cannot contend that he is not the owner and premises not comes within the purview of the premises which he had purchased. And the very admission is clear with regard to the fact that he was a licensee under the vendor of the plaintiff. And also specific admission is given in respect of the scheduled premises shown in the notice under reply. And hence the very same schedule is shown in the plaint also, which is mentioned in the notice also, and hence there is a clear admission with regard to the premises belongs to the vendor as well as he was a licensee. And hence the contention of the appellant cannot be relied upon. The counsel in support of his argument also relies upon the judgment of the apex court reported in 1985 within bracket 2 SCC 332 and brought to notice of this court paragraph number 6 and 8. And in paragraph number 6 discussed with regard to the termination of the license, comma, the licensee is under a clear obligation to surrender his possession to the owner. And if he fails to do so, comma, we do not see any reason why the licensee cannot be compelled to discharge this obligation by way of a mandatory injunction under section 55 of the Specific Relief Act. The counsel also brought to notice of this court paragraph number 8, wherein also apex court discussed that the respondent was a licensee and he must be deemed to be always a licensee. Full stop. It is not open to him, comma, during the subsistence of the license or in the suit for recovery of possession of the property instituted after the revocation of the license to set up the title to the property in himself or anyone else. Full stop. It is his plain duty to surrender possession of the property as a licensee and seek his remedy separately in case he has acquired title to the property subsequently through some other person. The counsel also relied upon the judgment of this court reported in the ALR 1999 Karnataka 236 and brought to notice of this court that this court, relying upon the judgment referred supra, comes to the conclusion invoking section 116 of the Evidence Act that it is clear that respondents having entered tenancy under a contract and recognizing the petitioners as their landlord by paying rents are clearly stopped from denying his title to the property. First off, in such a situation, the landlord need not establish his title to the leased property. The estoppel will continue to operate against him till the tenant acquires the landlord's title by a process known to law. The counsel also brought to notice of this court the discussion made by this court, even referring the judgment reported in the AR 1976 SC 337, Sriram Pasrecha versus Jagannath, wherein also discussed with regard to section 16 of the Evidence Act, extracting the relevant para. The counsel also brought to notice of this court that a discussion was made by this court that admittedly in this case respondent was put in possession of the property by the petitioner as a tenant. This decision therefore, comma, instead of helping the case of the respondent, advances the case of the petitioner. First off, therefore, there is no substance in this contention. First off, if the origin of possession is traceable as a lease or a licensee or a license granted by a person claiming to be a owner, comma, and when a person takes possession of the property either as licensee or a tenant, semicolon, it is no defense to the rule of estoppel, comma, to state that he is not aware of the title of such a person putting him in his possession. Semicolon, at the cost of repetition, it has to be said that the only remedy of such a party is first to surrender possession to the person from whom he got it, and therefore make a claim whatsoever, comma, either against the person or against the property. The counsel referring these two judgments would vehemently contend that when the defendant categorically admits that he is a licensee, and now he cannot deny the title, and also section 116 pressed into the service of the defendant. Having heard the appellant counsel and the counsel appearing the appellant in reply to the argument would vehemently contend that in paragraph number, the very same reply notice later, reply was given that at no point of time he was oblique is a licensee under the vendor of your client in respect of the said premises. And even denied that he was not a licensee. And the court has to take note of both the recitals in the reply notice also. Having heard the appellant counsel and also the counsel for the respondent, and also considering the factual aspects of the case, and no doubt the counsel appearing for the appellant brought to notice of this court that in the plaint itself in paragraph number 4, plaintiff has referred the reply notice denying the license and set up a contention that suit property shop room does not exist within the property purchased by the plaintiff, and also denying of the title of the plaintiff. The very claim of the plaintiff is based on the sale deed dated 7/7/2014, and the same is marked.
Two sale deeds. Exhibit P3 and P9. It
ಎರಡು
is
sale deed.
supplemental sale deed.
Huh?
Exhibit P3 is the supplemental sale deed. Exhibit P9 is the sale deed. Exhibit P3 is a copy. There are two sale deeds, P3 and P9.
Supplemental sale deed is 7/1/2014.
ಅದು ಸೇಮ್ ಡೇಟ್.
ಎರಡು ಸೇಮ್ ಡೇ
ಹೌದು, ಎರಡು ಸೇಮ್ ಡೇಟ್.
ಇನ್ನೊಂದು exhibit P3 and P9.
P9.
Why there are two sale deeds? ಅದೇ why there are two sale deeds ಅಂದೆ. ತೊಗೊಳ್ಳಿ. The very claim of the very claim of the plaintiff before the trial court is that he had purchased the property. But sale deed dated 7/1, ಅದು not 7/7. 7/1/2014. And also relies upon document exhibit P9 and also the exhibit P3 supplemental sale deed dated 7/1/2014. The specific case of the appellant also that the shop room not comes within the property which he had purchased. The fact that on the date of sale, exhibit P9.
P9 ಇಲ್ಲ. P9 copy ಇಲ್ಲ.
P9 ಇದೆ.
P3.
Third, the fact that notice was issued terminating the license. A notice was issued is not in dispute. And also reply was given to the said notice. The notice is marked as exhibit P5, that is dated 7/7/2014. And reply was given to the said notice in terms of exhibit P7 dated 30/7/2014. Having perused the said reply notice, which is marked as exhibit P7, in para 3 of the reply notice, a categorical unequivocal admission is made by the counsel who has issued the reply. And the said reply was given under the instructions of this defendant that his client had been a licensee under the vendor of the plaintiff in respect of the scheduled premises shown in the notice under reply, before the same is purchased by the plaintiff. And no doubt counsel appearing for the appellant brought to notice of this court that in page 2, in another para, at a denial is made at no point of time he was a licensee under the vendor of his client in respect of the said premises. But court has to take note of the reply in toto. when the clear admission was given at the first instance, both in respect of he was a licensee under the vendor of the plaintiff, and particularly in respect of the scheduled premises shown in the notice under reply. Before the plaintiff had purchased the property, he was a licensee. And later, if he makes any such statement that at no point of time denying he was not a licensee, and the admission given by him cannot be taken out later on, denying the same. Once an admission is an admission always. And hence the very contention of the appellant counsel that he was not a licensee cannot be accepted. The legal notice exhibit P5, wherein specifically mentioned the schedule as well as specific statement is made that he was a licensee under the vendor. And even in the reply notice also a specific admission is given that he was a licensee under the vendor of the plaintiff, particularly in respect of the premises which has been shown in the legal notice itself. And hence the said contention cannot be accepted. The other contention of the appellant counsel that the plaintiff has to prove his case on his own strength. And no doubt the principles which have been relied upon by the appellant counsel is in respect of when the suit is filed for the relief of declaration. And also it is settled law also in a case of declaration, the plaintiff cannot depend on the weakness of the defendant, and he has to prove his case on his own legs and also on his own strength, not on the weakness. And the said judgment are in respect of when the relief is sought for the relief of declaration. Declaration ಇದ್ದಾಗ ಅದು ಬರ್ತದೆ title prove ಮಾಡ, and the same is in respect of the title is concerned, and the same is also settled law. The counsel appearing for the respondent also relied upon the judgment with regard to when there is a clear admission with regard to the licensee or as a tenant, and also apex court held in the judgment 1985 as brought to the notice of this court paragraph number 6 and 8 that when the respondent was a licensee and he must be deemed to be always a licensee and he cannot dispute the same unless he prove the contrary. This court also in the judgment referred supra reported in ILR 1999 Karnataka 236 also categorically held that once the material discloses that he was a licensee or tenant and he cannot even deny the title. And in the case on hand, when he has categorically admitted in the reply notice that he was a licensee under the vendor of the plaintiff, now he cannot dispute the same and cannot deny the title also. The other contention is that he had constructed the shop room in the government building. And though such defense was taken by the defendant before the trial court, no document is placed before the court in order to substantiate the same. And even the plaintiff succeeds based on the very admission on the part of the defendant who has admitted that he was a licensee under the vendor of the plaintiff and he cannot dispute later on. The other contention is that the commissioner who has been appointed to identify the property and he was unable to identify the same as there was no any survey assistance for him. And no doubt the said discussion is also made by the trial court as well as the first appellate court. No doubt the appellant counsel brought to notice of this court the discussion made by the first appellate court with regard to the proving of the case, and burden is on the defendant to prove the said fact. And that observation made by the appellate court is not correct and need not prove the defendant his case. But the fact is that when the clear admission is on the part of the defendant that he was a licensee under the vendor of the plaintiff, and also in respect of the shop premises which he had purchased, And also he categorically stated in respect of the scheduled premises is concerned. He was a licensee under the vendor of the plaintiff. And identity of the property is also not disputed while giving the reply. Though later contend that he is not a licensee, and her court has to take note of the unequivocal admission on the part of the defendant, particularly in exhibit P7, and the said notice was given immediately after the reply, immediately after the issuance of notice and termination of notice, and the fact that license was terminated by issuing the notice in terms of exhibit P5 is not in dispute, and when such being the case, and when both the courts have taken note of the material available on record and given the fact finding and question of admitting the second appeal doesn't arise, and I do not find any ground to frame any substantive question of law. And the finding of both the courts are not perverse, and the same is based on the material and particularly on the admission on the part of the defendant when he categorically admitted that he was a licensee under the plaintiff vendor. And now the appellant cannot blow hot and cold, saying that he was not a licensee when the clear admission was given in the reply notice itself before approaching the court. In view of the discussions, Madam, I pass the following order. Appeal is dismissed. ಮೇನ್ ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ ಇನ್ನೇನು ಪ್ರೆಸಿಪಿಟೇಟ್ ಬರ್ತದೆ, ಅದ್ ಬರೋದೇ ಇಲ್ಲ, ಅದೇನು ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ. ಮೆರಿಟ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಏಕೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್
I'm ready.
and counsel for the appellant is present and ready. List this matter on 4/7.
ಅಲ್ಲ ಫೋರ್ತ್ ಬೇಡ ಸ್ವಾಮಿ, ಆ ವಾರ ಇರಲ್ಲ.
ಯಾವತ್ ಬೇಕು ಹೇಳಿ,
12th
ಮುಂಚೆ ಆಗುತ್ತಾ ಅಥವಾ ಆಮೇಲೆ ಬೇಕಾ?
12 ಅದ್ರ ಆದ್ಮೇಲೆ 12th or 15th ಮೇಲೆ
12th ಆಯ್ತು, 12/7.
ಮಚ್ಚು
12/7.
ಇನ್ಮೇಲೆ RFA ಹೋದ್ಮೇಲೆ ತಮ್ಮ ಮುಂದಿನ ಎಲ್ಲ RFA ಗಳೆಲ್ಲ ಹೋಯ್ತಲ್ಲ ಸ್ವಾಮಿ, ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್
ಈಗ
ಇಂದ
ಮೊನ್ನೆ ಇದನ್ನ ಮಾಡಿ
ಆಲ್ RFA ನೋ ಮೈ ಲಾರ್ಡ್
ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದಾರೆ ನೆನ್ನೆ.
ಬಂತಾಯ್ತು. ಈಗ ಎಷ್ಟು ಬೆಂಚ್ಗಳಾದ್ರೂ RSAಗಳು ಮತ್ತೆ ಎಕ್ಸ್ಟ್ರಾ ಮತ್ತಷ್ಟು ಬೇಕಾಗುತ್ತೆ.
ಕೇಸ್ಗಳು ಎಷ್ಟಾಗ್ತದೆ, ಬಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ಜಾಸ್ತಿ ಹೋಗ್ತದೆ,
ಬರ್ಡನ್ ಜಾಸ್ತಿ ಆಗ್ಬಿಡುತ್ತೆ ಸ್ವಾಮಿ. ಆಮೇಲೆ 2007 ಇಂದ ಮಾಡಿರೋ ನೋಟಿಸ್ಗಳಿಂದ ಹಿಡಿದು ಬರ್ಬೇಕು.
ಒಳ್ಳೇದು ಯಾಕೆ ಅಂತ ಹೇಳ್ತೀನಿ
ಸ್ವಾಮಿ,
ನಮ್ಮಲ್ಲೆಲ್ಲ ಸೆಕೆಂಡ್ ಅಪೀಲು 15 ವರ್ಷ 20 ವರ್ಷ ಇರ್ತದೆ. ಅದ್ರ ಬದಲು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ಗಳು ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ವರ್ಕ್ ಕಡಿಮೆ ಇದೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ಗಳಿಗೆ. ಅವ್ರಿಗೆಲ್ಲ 400-500 ಕೇಸ್ ಇರುತ್ತೆ. ನಮ್ಮಲ್ಲಿ 4,000, 5,000, 6,000 RSAಗಳು ಇರುತ್ತೆ ಒಬ್ಬೊಬ್ರು. ದಟ್ ಈಸ್ ಬೆಟರ್. ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಇಟ್ ಇಸ್ ಬೆಟರ್, ನಾಟ್ ಟೆಂಪರರಿ ಸೊಲ್ಯೂಷನ್, ಪರ್ಮನೆಂಟ್ ಸೊಲ್ಯೂಷನ್.
ಅಲ್ಲ ಸ್ವಾಮಿ, 15 ಲಕ್ಷ ಆಗಿದ್ದು
ಆಯ್ತ್ರಿ, ಆ ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಮಾತ್ರ ಇನ್ವಾಲ್ವ್ ಆಗ್ತದೆ. ನೀವು RFA ಅಂತಂದ್ರೆ ಮತ್ತೆಲ್ಲ ಬಂದ್ಬಿಡ್ತದ, ಫ್ಯಾಕ್ಟ್ಸ್ ಲಾ ಎಲ್ಲ
ಇಲ್ಲ. ಅಲ್ಲಿ ಒಂದು ತಪ್ಪು ತಿಳಿಬಾರ್ದು ನ್ಯಾಯಾಲಯ. ಪ್ರೆಸಿಡೆನ್ಷಿಯರಿ ವ್ಯಾಲ್ಯೂ ತಾವೇನ್ 96 ಅಲ್ಲಿ ಮಾಡ್ತಿದ್ರಿ, ಅದು ವಿ ವಿಲ್ ಶಾಶ್ವತವಾಗಿ ಹೊರಟೋದಂಗ್ ಸ್ವಾಮಿ. ಈಗ ಯಾಕಂದ್ರೆ 100 ಅಲ್ಲಿ ಬೇಕಾದಷ್ಟು ರಿಸ್ಟ್ರಿಕ್ಷನ್.
ಯಾವುದೇ ಲಾ ತರಲಿ ಅಡ್ವಾಂಟೇಜಸ್ ಇರುತ್ತೆ, ಡಿಸ್ಅಡ್ವಾಂಟೇಜಸ್ ಇರ್ತದೆ. ವಿ ಹ್ಯಾವ್ ಟು ಸಿ ದಿ ಲಾರ್ಜರ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಷ್ಟೇ.
ಅದೇ
ಏನಾಗ್ತದೆ ಇಲ್ಲೆಲ್ಲ ಬಂದು ನೀವೇ ನೋಡ್ತೀರಿ. ಈಗ 2005 ಸೆಕೆಂಡ್ ಅಪೀಲ್ಸ್ ಇದೆ ಮೋಸ್ಟ್ಲಿ.
ಇದೆ ಸರ್.
ನಾನು ಇವನ್ 2003 ಸೆಕೆಂಡ್ ಅಪೀಲ್ಸ್ ಆಲ್ಸೋ ಡೆಲ್ಟ್ ಲಾಸ್ಟ್ ಇಯರ್ ಅಲ್ವಾ, ಆಲ್ಮೋಸ್ಟ್ 20 years RSAs ಅಲ್ವಾ
ಪೆಂಡಿಂಗ್.
ಅದ್ರ ಬದಲು ಈಗ ಅಲ್ಲೇ ಆಗಿರೋ ವ್ಯಾಲ್ಯೂ ಎಲ್ಲ ಏನ್, ಈಗ ನಾನು ಒಂದ್ ಸಿಂಪಲ್ ಇದು ನೋಡ್ರಿ, ಸಿವಿಲ್ ಜಡ್ಜ್ಗೆ ನೋ ಜೂರಿಸ್ಟಿಕ್ಷನ್, ಎಷ್ಟು ಕೋಟಿ ರೂಪಾಯಿದಾರು ವ್ಯಾಲ್ಯೂ ಡೀಲ್ ಮಾಡ್ಬೋದಂತೆ ಪ್ರಾಪರ್ಟಿಯ. ಅದೇ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಬರೀ 10 ಲಕ್ಷ ಅಂತೆ. ದಟ್ ಈಸ್ ಅನ್ ಅನಾಮಲಿ ಅಲ್ವಾ. ಅವ್ರಿಗೆ 10 ಲಕ್ಷ ಡಿಸೈಡ್ ಮಾಡ್ಬಿಟ್ಟು ನೀವು ಸಿವಿಲ್ ಜಡ್ಜ್ಗೆ ಕೋಟಿಗಟ್ಟಲೆ ಆಸ್ತಿನ ಡೀಲ್ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿ ಕೊಟ್ರೆ ನಿಮ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಸೂಟ್ಸ್ ಅಲ್ಲಿ ನೋ ಮೀನಿಂಗ್ ಅಟ್ ಆಲ್.
ಬಟ್ 15 lakhs ಎನ್ಹಾನ್ಸ್ ಆಗಿದ್ದು ಅದು ಮತ್ತೆ
15 ಆದ್ರೂ ಇವತ್ತಿನ ರೇಟ್ ಅಲ್ಲಿ ಏನ್
15 lakhs ಬೆಲೆ ಇಲ್ಲ. ಅದೇನೋ ಸರ್ ಮಾನಿಟರಿ ಇದು
ಏನ್ ನೋಡೋಣ, ಒಂದು ಎಕ್ಸ್ಪೆರಿಮೆಂಟ್ ಆಗಿದೆ ನೋಡೋಣ.
ಅಲ್ಲ, ಅವಾಗ ಹಿಂದೆ ಬಹಳ ತಮ್ಮ ಜ್ಞಾಪಕ ಇರೋಂಗೆ ಈ ರೆವಿನ್ಯೂ ಅಪೆಲೇಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಆಯ್ತಲ್ಲ ಸರ್.
ನಾನ್ ಹೇಳೋದು ಏನು ಅಂದ್ರೆ, ಒಂದು ಇದನ್ನ ಏನ್ ಮಾಡಿದಾರೆ ಅದು ರೆಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಎಫೆಕ್ಟ್ ಮಾಡಬಾರ್ದಾಗಿತ್ತು. ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಮಾಡ್ಬೇಕು.
ಮಾಡ್ಬೇಕು.
ಯಾಕೆ ಗೊತ್ತಾ? ಐ ರೈಸ್ ದಿಸ್ ವಾಯ್ಸ್ ಇನ್ ದಿ ಬಿಗಿನಿಂಗ್ ಇಟ್ ಸೆಲ್ಫ್. ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಈಗ ಇಲ್ಲಿಗೆ ಬಂದಿರ್ತಾರೆ,
ಹೌದು
ಹೈಕೋರ್ಟಿಗೆ ಲಾಯರಿಗೆ ಫೀಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ.
ಹೌದು
ಈಗ ಮ್ಯಾಟರ್ ವಾಪಸ್ ರೆಫರ್ ಆಯ್ತು ಅಂದ್ರೆ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ ಲಾಯರಿಗೆ ಕೊಟ್ಟು ಫೀಸ್ ಹೋಯ್ತು. ಮತ್ತೆ
ಮತ್ತೆ
ಅಲ್ಲಿ ಹೋಗಿ ಈಗ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮತ್ತೆ ಹೋಗಿ ಅಲ್ಲಿ ಲಾಯರಿಗೆ ಫೀಸ್ ಕೊಡ್ಬೇಕು. ಇಟ್ ಈಸ್ ಎ ಬರ್ಡನ್ ಆನ್ ದಿ ಕ್ಲೈಂಟ್,
ಅಷ್ಟೇ.
ಸೀಕರ್ಸ್ ಆಫ್ ಜಸ್ಟಿಸ್. ನ್ಯಾಯ ಯಾರು ಕೇಳ್ಕೊ ಬರ್ತಾನೋ
ಅವ್ರು ಮತ್ತೆ
ಅವ್ರಿಗೆ ಅನ್ಯಾಯ ಆಯ್ತು ಇದರಿಂದ.
ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅಂದ್ರೆ ಇದನ್ನ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಮಾಡ್ಬೇಕಿತ್ತು.
ಹೌದು.
ಮುಂದೆ ಬರ್ತಕ್ಕಂತ ಸೂಟ್ಸ್ ಏನೇನ್ ಇದೆಯೋ ಅದನ್ನೆಲ್ಲ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಮಾಡಿ ಈಗಿರ್ತಕ್ಕಂಥದ್ನ ರೆಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಮಾಡ್ದಲೇನೆ ಮಾಡಿದ್ರೆ ಅನುಕೂಲ ಆಗ್ತಾ ಇತ್ತು.
ಈಸಿ ಆಗ್ಬಿಡುತ್ತೆ.
ಒಂದು. ಎರಡನೇದು ಏನಾಗ್ತದೆ, ಈಗ ಇಲ್ಲಿಂದ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೋಗ್ತದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಮತ್ತೆ ಸರ್ವಿಸು ನೋಟಿಸು,
ಹೌದು.
ಇಟ್ ಮೇ ಟೇಕ್ಸ್ ಮೋರ್ ಟೈಮ್. ಫೀಸ್
ಫೀಸ್
ಅಲ್ವಾ? ಇಟ್ ಈಸ್ ಎ ಬರ್ಡನ್ ಆನ್ ದಿ seekers of justice,
ಲಿಟಿಗೇಟ್ಸ್.
litigants. Ultimate sufferer is the litigant. Litigant is the person who is approaching the court with a fond hope that they would get the justice. But now what we are doing? No speedy and higher caste. Higher caste.
But ಬೇರೆ ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ. We have to wait and see what will be the implication from our state, because none other state is having that. Even original jurisdiction ಇರೋ ಕಲ್ಕಟಾ, ಮಡ್ರಾಸ್ ಅಂಡ್ ಬಾಂಬೆ ಹೈಕೋರ್ಟ್ಸ್,
ಕೆಲವು
ಹೈಕೋರ್ಟ್ಸ್ ಲೆಟರ್ಸ್ ಪೇಟೆಂಟ್ ಅಪೀಲ್ ಅಲ್ಲೆಲ್ಲ ಹಾಗೆ ನಡ್ಕೊಂಡೇ ಬಂದಿದೆ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಡೆಲ್ಲಿ.
Unless they remove the original jurisdiction, that
Yes.
will continue.
Continue.
Because we have appellate jurisdictions ಅಲ್ವಾ?
ಅಲ್ಲ
ಅಷ್ಟೇ, ಒರಿಜಿನಲ್ jurisdictions ಇಲ್ಲ. No, we'll
ಪ್ಲೀಸ್
see.
ಮಚ್.
But ultimate sufferer is the seeker
Yes
of
my lord,
justice.
that's the hard reality.
Seekers of justice.
ಇಲ್ಲ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಆಗಿದ್ರೆ
ನಾನು ಅದನ್ನೇ ಹೇಳೋದು. ನಾನು I said on the very same day
Please.
that it should be not retrospective, it should be prospective. ಈಗ ಏನಾಗ್ತದೆ, ಎಲ್ಲ ಕೇಸ್ ಮತ್ತೆ ಇಲ್ಲಿಂದ ವಾಪಸ್ ಹೋಗ್ಬೇಕು, ಅಲ್ಲಿ ಮತ್ತೆ ಅವನು ಹೋಗಿ ಲಾಯರ್ ಫೀಸ್ ಕೊಡ್ಬೇಕು, ಇಲ್ಲಿ ಕೊಟ್ಟಿರ್ತಾನೆ.
ಕೆಲವು ಪಾರ್ಟ್
ಮತ್ ಸರ್ವಿಸ್ ನೋಟಿಸ್
ಸರ್ವಿಸ್ಗೆ ಹೋಗ್ಬೇಕು, ಪಾರ್ಟ್ ರೆಡ್ ಕೆಲವಾಗಿರುತ್ತೆ, ರಿಸರ್ವ್ ಆಗಿರುತ್ತೆ. ಮಚ್ಚ
ಆಯ್ತು ನೋಡೋಣ. anyhow ನಮ್ jurisdiction will not be changed now because we are RS, we are dealing with RSA we have to deal. RFA ಗಳಲ್ಲಿ ಮಾತ್ರ ವಾಪಸ್ ಹೋಗ್ತದೆ ಅಷ್ಟೇ. ಜಾಸ್ತಿ ಆಗ್ತದೆ. ಇಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಆಗ್ತದೆ ಈಗ. ಇನ್ನೊಂದು ಅನಾಮಲಿ ಇದೆ ನೋಡಿ, ಕ್ರಿಮಿನಲ್ ಸೈಡ್. ಈಗ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಲೈಫ್ ಸೆಂಟೆನ್ಸ್ ಕೊಡ್ಬೋದು, ಡೆತ್ ಸೆಂಟೆನ್ಸ್ ಕೊಡ್ಬೋದು, ಎಲ್ಲ ಕೊಡ್ಬೋದು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್. ಬಟ್ ಇಲ್ಲಿ ಹೈಕೋರ್ಟಿಗೆ ಬಂದ ತಕ್ಷಣ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ ಕೆನಾಟ್ ಡೀಲ್ ವಿತ್ ದಿ ಪನಿಷ್ಮೆಂಟ್ ಆಫ್ ದಿ ಲೈಫ್ ಸಿಂಗಲ್ ಜಡ್ಜ್.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗ್ಬೇಕು.
He should go to the division
bench.
No meaning in
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್ ಹಂಗೆ ಇದೆ, ಆರ್ಬಿಟ್ರೇಷನ್
ಒಂದೊಂದಲ್ಲ ಎಲ್ಲಾದ್ರಲ್ಲಿ ಇದೆ. ಬಟ್ we have to see the larger interest.
Exactly.
Discussed in the morning in Court Hall 3. Because Justice Hegde's judgment was instrumental in. So ultimately ಇದೆಲ್ಲ ಈಚೆ ಬಂದಾಗ then Justice Hegde opined amendment ಗೂ amendment ಬೇಕಾಗತ್ತೆ.
ಅಲ್ಲ ಸಾಹೇಬ್ರು ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬಿಟ್ರು.
Describe family court appeals, arbitration at the commercial divisions. We don't, and the largest loser is not on the civil appeal side. Civil appeal side, we will lose these higher questions of law, because here your lordship will be dealing only with substantial questions of law. Within that window, we'll have to enlarge. We will lose the opportunity of actually presenting a first appeal and dealing with it.
Almost.
That is the loss. That is the loss of the civil bar side. That is the loss. Can we say the same thing to the criminal lawyers, saying that no, you have a appeal before the district court case? No. They treat it as if it's a right to life and liberty. Here, Manoj, it's estate. In fact, it's more than that. If a person dies, Manoj, in a criminal trial, he dies. If the estate goes, Manoj, he's stripped off.
That will have
The legacy is stripped off. That's why, Manoj, that appellate bench.
There are lot of
ramifications are.
That's why Justice Ravindra ಅವ್ರದ್ದು ಬಹಳ ಒಂದು ಅಥಾರಿಟೇಟಿವ್ ಕಾಮೆಂಟ್ರಿ ಎಲ್ಲ ಮಾಡಿದಾರೆ ನೋಡಿ. Are the lacunas in
Yes.
law ಅನ್ನೋದನ್ನ ಹೇಳಿದ್ದಾರೆ. ಬಟ್ ದಿ framers of law should think of it.
they should have taken into consideration this. ಇನ್ನೊಂದಾಗುತ್ತೆ ಸ್ವಾಮಿ, ಒಂದೊಂದ್ಸಾರಿ ನಮ್ಗೆ ಆಶ್ಚರ್ಯ ಆಗುತ್ತೆ, ತಾವು ತಪ್ಪು ತಿಳಿಬಾರ್ದು. RSAಗಳಲ್ಲಿ ತಾವು ಕೇಳಿದಷ್ಟು ಸಾವಧಾನವಾಗಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜಸ್ ಆಗ್ಲಿ, ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಅಲ್ಲ, ಅವ್ರನ್ನ ತಪ್ಪು ಅನ್ನಲ್ಲ, ಆರ್ಯಗಳು ಕೇಳಲ್ಲ. ಅನೇಕ ಬಾರಿ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿಂತಾರೆ. ಒಂದೊಂದ್ಸಾರಿ ನಮ್ ಕಡೆಯಿಂದಲೂ ತಪ್ಪಾಗಿರುತ್ತೆ, ಅದು ಫೌಂಡ್ ವೆರಿಫೈಡ್ ಕರೆಕ್ಟ್ ಅಂತ ಸೀಲ್ಗಳು ಬಿದ್ದ್ಬಿಡ್ತವೆ. ಅದು
ನೀವು ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ, ನಾನು ಅಡ್ಮಿಷನ್ ಬರೋವಾಗ ಎಲ್ಲಾ ಫೈಲ್ಸ್ ಓದ್ಕೊ ಬರ್ತೀನಿ.
ಹೌದು.
ದ ರೀಸನ್ ಈಸ್ ಆಲ್ ಲಿಟಿಗೇಂಟ್ಸ್ ಆರ್ ನಾಟ್ ಅಫೋರ್ಡಬಲ್ ಟು ಗೋ ಟು ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
ಇಟ್ಸ್ ಎ
ಕೆಲವು ಲಾಯರ್ಸ್ ಗಳು ಬರ್ತಾರೆ, ಓದ್ಕೊ ಬಂದಿರ್ಲಿಲ್ಲ, ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡಲ್ಲ. ಅದರಿಂದ ನಾವು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರೆ ಅಲ್ಟಿಮೇಟ್ ಸಫರರ್ ಆರ್ ದಿ ಲಿಟಿಗೇಂಟ್ಸ್. ದೇ ಶುಡ್ ನಾಟ್ ಸಫರ್ ಅಂತ ಐ ಯೂಸ್ ಟು ಟೇಕ್ ದಿ ಪೇನ್. ನೀವು ನೋಡ್ಬೋದು, ನಾನು ಅಡ್ಮಿಷನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ನೋಟ್ಸ್ ಓದ್ಕೊ ಬರ್ತೀನಿ ನಾನು. ದ ರೀಸನ್ ಈಸ್ ರೀಸನ್ ಈಸ್ ಬಂದಾರೇನೋ ಹೇಳ್ತಾರೆ ಅಂದ್ಬಿಟ್ಟು ಅದ್ರ ಮೇಲೆ ನಾ ಬರೆಯಕ್ಕಾಗಲ್ಲ. ಬಟ್ ಐ ಶುಡ್ ಹ್ಯಾವ್ ದಿ ಲುಕ್ ರೆಕಾರ್ಡ್ಸ್, ಶುಡ್ ಲುಕ್ ಇನ್ ಟು ದಿ ರೆಕಾರ್ಡ್ಸ್. ಈಗ ಎಲ್ಲಾರ್ಗು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗೋದ್ರೆ ಹೋಗಕ್ಕಾಗುತ್ತಾ? ಈಗ ಹೈಕೋರ್ಟಿಗೆ ಬರೋದೇ ಕಷ್ಟ ಆಗ್ಬಿಟ್ಟಿದೆ,
ಕಷ್ಟ ಆಗಿದೆ
ಅಲ್ವಾ?
ಇನ್ಮೇಲೆ ಇನ್ನ ಕಷ್ಟ.
ಇನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಇನ್ನೂ ಎಷ್ಟು ಕಷ್ಟ. ಅಲ್ಲಿ ಫೀಸ್ ನೋಡ್ಬೇಕಲ್ಲ, ಎಲ್ಲಾರು ಹೋಗಕ್ಕಾಗಲ್ಲ. ಆ ಫೀಸ್ ಕೊಡಕ್ ಆಗ್ದಲೆ ಎಷ್ಟೋ ಜನ ಬೇಡ ಸಾಕು ಇಲ್ಲಿಗೆ ಮುಗ್ದೋಗ್ಲಿ ಅಂತ ಅನ್ಕೋತಾರೆ. ಆ ತರದ ಅನ್ಯಾಯ ಆಗೋದ್ ಬೇಡ ಅಂತ ಐ ಟೇಕ್ ಪೇನ್. ಇಮಿಡಿಯೇಟ್ ಆಗಿ ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ ತಕ್ಷಣ ನಾನು ಆರ್ಡರ್ ಬರೆಯೋದು ಇಲ್ಲ. ಇವನ್ ನಾನು ಓದಿದ್ರು ಮತ್ತೊಂದ್ಸರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನ್ ಆರ್ಡರ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಬರ್ತಿದ್ದಾರೆ, ಅದನ್ನ ಓದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಐ ಸ್ಟಾರ್ಟ್ ದಿ ಡಿಕ್ಟೇಷನ್.
ಈವನ್ ನಮ್ ಹೇಳಿದ್ರಲ್ಲಿ ಒಂದ್ ಸ್ವಲ್ಪ ತಮ್ ಕಾಣಿಸಿದ್ರು LCR ಕಾಲ್ ಫಾರ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಅಡ್ವಾಂಟೇಜ್.
ಅದಕ್ಕೆ ಇಲ್ಲ ಅಂದ್ರೆ ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ರೆಕಾರ್ಡ್ ನೋಡ್ ಮಾಡೋಣ ಅಂತ ರೆಕಾರ್ಡ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿ ಆಮೇಲೆ ಕೇಸ್ ಇದ್ರೆ ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಮಾಡ್ತೀವಿ. ದೆನ್ ವಿಲ್ ಹಿಯರ್ ದಿ ಮ್ಯಾಟರ್.
ಪ್ಲೀಸ್, ಯೂನಿಫಾರ್ಮಿಟಿ ಇಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ ಇನ್ ಆರ್ ಸ್ಟೇಟ್ ನಾಟ್ಸ್ ಒಂದು RSA ಅಂದ್ರೆ ದಿ ಮಿನಿಮಲಿಸ್ಟಿಕ್ ಡಿಸ್ಪೋಸಲ್ ವಿಲ್ ರನ್ ಟು 5-6 pages. In other states not, it's 2 pages. Heard, no substantial question of law made out, dismissed.
ನೋಡಿದೀವಿ ಸರ್.
What happens if someone else comes? I'm not saying that practice is incorrect. That is the danger. What I was saying.
I don't want to comment.
ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಡೊಮೈನ್ ಅದು.
ಯಾಕಂದ್ರೆ RSA ಡೀಲ್ ಮಾಡುವಾಗ we have to read the plain written statement,
ಪ್ಲೀಸ್
issues, reasoning of the trial court, evidence and first appellate court grounds, formulation of point. ನಾನು ಅದು ಮೊನ್ನೆ ಒಂದು ಬರ್ದಿದ್ದೀನಿ ನೋಡಿ, ಒಂದು RSA ನಲ್ಲಿ ಬರ್ದಿದ್ದೀನಿ. ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ವೆದರ್ ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ದಿ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂತ ಬರೀತಾರೆ ನಮ್ಮ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಗಳು RNL ಮಾಡುವಾಗ. ದಟ್ ಈಸ್ ನಾಟ್ ದಿ ಕರೆಕ್ಟ್. ಇದು ನಾನು ಬರ್ದಿದ್ದೀನಿ, ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲರಿಗೂ ಹಾಕಿ ಅಂತ ಹೇಳಿದೀನಿ, ಆಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜಸ್ಗೆ ಸರ್ವ್ ಮಾಡಿ ಅಂತ. ಕ್ರಕ್ಸ್ ಆಫ್ ದಿ ಇಶ್ಯೂ ಏನಿದೆಯೋ ಅದನ್ನ ಪಾಯಿಂಟ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ಮಾಡಿ ಈವನ್ RNL ಕೂಡ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು ಅಂತ. ನೀವು ನೋಡ್ಬೇಕು, ಕೆಲವೊಂದು ಇನ್ವೇರಿಯಬಲಿ ಸಮ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜಸ್ ಆರ್ಡರ್ ಬರೆಯುವಾಗ ವೆದರ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಕ್ರಿ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಕ್ವೈರ್ಸ್ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಆರ್ ನಾಟ್, ಅದು ಒಂದೇ ಇರ್ತದೆ. ಅದ್ ಮಾಡ್ಬೇಕು,
ಮೆಜಾರಿಟಿ
ಮಾಡಿಲ್ಲ ಅಂತ ನಾನೇ ಒಂದ್ ಎಲ್ಲರಿಗೂ ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿದ್ದೀನಿ
ನೋಡಿ.
ಅಂದ್ರೆ ಸೂಪರ್ಫಿಷಿಯಲ್ ಡಿಸ್ಪೋಸಲ್,
ಹೌದು,
ನಾಟ್ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ಇದು. ನಾ ರಿಪೋರ್ಟೆಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೂಡ ಅದು ಹಾಕಿದ್ದೀನಿ, ಯಾವ್ದೋ ಒಂದು ಕೇಸಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ, ಅದ್ರಲ್ಲಿ ಹಾಗೆ ಆಗಿತ್ತು. ಆತರ ಇದೆ. ವೈಲ್ ಡೀಲಿಂಗ್ ವಿತ್ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ವಿ ಶುಡ್ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ.
ಪ್ಲೀಸ್,
ನಾನು ಒಂದು 1.5 ಮಾಡಿದ್ದೀನಿ RSA.
ಇತ್ತ ಒಂದ್ಮೇಲೆ ನಾವು ಎಲ್ಲ
RSAಗಳನ್ನ ಒಂದು ಆಲ್ಮೋಸ್ಟ್ 1.5 ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ.
ಪ್ಲೀಸ್.
ಎಸ್ ತೊಗೊಳ್ಳಿ. 92 ಮೋಸ್ಟ್ಲಿ ಅದು ನೋಟಿಫಿಕೇಶನ್ ನೆನ್ನೆ ಮಾಡಿರ್ಬೇಕು, ನೆನ್ನೆನ ಮನೆ 19th ನೆನ್ನೆ ಬಂದಿರ್ಬೇಕು. ತಗೊಳಲ್ಲ.
ಕಾಸ್ ಲಿಸ್ಟ್ ಏನಾಗ್ಬೇಕು ಅನ್ನೋದು ಈಗ ನಮ್ಗೆ ಯೋಚನೆ
ಅಲ್ಲ, ಅದು ಸ್ವಲ್ಪ ಡೌಟ್ಸ್ ಇದೆ ಸ್ವಲ್ಪ. ಅದಕ್ಕೆ ನನ್ನ ಪ್ರಕಾರ ನಾನು ಐ ಸಜೆಸ್ಟೆಡ್ ಯು ಫಸ್ಟ್ ಕಾಲ್ ದಿ full court and we have to address certain issues. Then otherwise now the advocates who are practicing before the trial court and also practicing before the high court, they are under dilemma with regard to certain issues. That has to be dealt with by the full court and then take decision. No, we'll see. 92 adjourn agide. 93
respondent
HS Suhas and T Sheshgiri Rao.
Food for recovery may not, it was dismissed before the trial court, decreed before
I appear for the
Divergent finding.
divergent finding may not.
Idara HS
Plea
Suhas.
of discharge was taken by the defendant, not proved. That is all.
I appear for the
For recovery, plea for.
Yes,
plea of-
counsel.
Millards, I am led by learned senior counsel in this matter. He's on his legs, Millards. May I request for any other day, just one accommodation, Millards?
The appellant counsel seeks time and counsel for the respondent is present. List this matter on. ಯಾವಾಗ ಬೇಕು? When do you want counsel?
Looks any date convenient. to the court.
Hmm?
Any date convenient to the court.
ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀರಾ ಮೇಡಮ್? 4/7 ಏನಾ? ಜಾಸ್ತಿ ಆಯ್ತಾ 4/7? ಆಯ್ತು 4/7.
Please. Grateful.
Suit for specific performance,
Yes.
Hmm.
Almost divergent, concurrent findings,
concurrent finding.
but with.
You are
variation.
appearing for respondent, madam?
On behalf of Sidmala, fourth respondent,
ಹಾ,
third respondent.
ರೆಡಿನಾ?
ಈಗ
ಅಲ್ಲ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಈಗ ಏನ್ R3 ನೀವು ರೆಡಿ ಇದ್ರೆ ಹಿಯರ್ ಮಾಡ್ತೀನಿ ನಾನು. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದೆ ಅದಕ್ಕೆ.
ಟಯರ್ಡ್ ಆಗ್ಬಿಟ್ಟಿದೆ,
ಹಾ?
ಟಯರ್ಡ್ ಆಗ್ಬಿಟ್ಟಿದೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್
Some other day.
ಸಂಬಂಧ.
Court is not tired. Maybe you have.
ಅಲ್ಲ ನೀವು ಇಲ್ಲ ಅಂದ್ರೂ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತದೆ. ನಾವು ವಿ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಡೂ ದಟ್ ಆಫ್ಟರ್ ಕೋರ್ಟ್ ಟೈಮ್ಸ್. ಕೋರ್ಟ್ ಟೈಮ್ ನೊಳಗೆ ಇಷ್ಟೆಲ್ಲ ಮಾಡ್ತೀರಲ್ಲ ಅಷ್ಟೇ ಸಾಕು ನಮ್ಗೆ.
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಿರೋದು ಐ ಆಮ್ ನಾಟ್ ಟೈರ್ಡ್ ಅಂದ. ಕಂಟಿನ್ಯೂ ಅಂತ ಆಯ್ತು. ನೀವು 30 minutes 15 minutes ಇದೆ, ಆಗೋದಿಲ್ಲ ಇವತ್ತು. ಕಮೆಂಟ್ಸ್ ಆದ್ರು ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ನಿಮ್ದು?
Half an hour.
ಹಾಫ್ ಅನ್ ಅವರ್ ಬೇಕು. ಈಗ ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಇದ್ರಲ್ಲಿ R3 ಪರವಾಗಿ?
ಹಾ ನಮ್ಮ
ಹಾ ಸರಿ ತೊಗೊಳ್ಳಿ.
ಸ್ವಲ್ಪ ಅವ್ರಿಗೆ ಕಣ್ಣು ಫ್ರೆಶ್ ಟ್ರೀಟ್ಮೆಂಟ್.
ತೊಗೊಳ್ಳಿ. ಫಾರ್ appellant counsel present and counsel for R3 seeks time. List this matter on 4/7.
Please.
4/7. ಸರ್ವಣ ಇದೇನ ಕೇಳಿದ್ರು ಬೆಳಗ್ಗೆನೆ. Appellant counsel seeks time and counsel for the respondent R3 intimate ಮಾಡಿದ್ರು ಅವ್ರಿಗೆ. Is absent. List this matter on 4/7. If respondent counsel doesn't appear in the next date of hearing, appeal will be heard in his absence. 98 Rajanna.
Was appearing for the
Yes,
response
ready?
already. Senior is right.
Seniors?
Seniors here, my lord.
Sorry. Appellant counsel is absent. Senior the respondent is present. If the appellant counsel doesn't appear in the next date of hearing, appeal will be dismissed. List this matter on 4/7. Appellant.
We'll take it up next week.
Okay, ready?
Lord said, last week admitted the matter. ಅದು ಪೇಪರ್ ಬುಕ್ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದ್ರಿ.
Admit ಆಗಿರೋದು recent ಆಗಿ.
ಹೌದು.
ಆಯ್ತು ಆಯ್ತು. Appellant counsel seeks time and counsel for the respondent is also present. List this matter on. ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. 4/7. 99 Santosh S. Nagarala Subramanya.
Appearing on behalf of counsel for respondents, Your Honor.
Respondent Nagarala ಹೇಳ್ರಿ. ರೆಡಿ ಇದೀರಲ್ಲ? ರೆಡಿನಾ? ಹಾ.
Your lordship may kindly take this matter on any other day. Senior is not.
Senior?
Senior is not there.
Senior is not well. ಏನಾಯ್ತು ಸೀನಿಯರ್ಗೆ?
Is feeling a bit
Huh?
cold.
ಕೋಲ್ಡ್ ಒಳ್ಳೆ ಔಷಧಿ ತಗೊಂಡ್ರಾಯ್ತು.
That's a divergent finding. It's a matter.
Appellant counsel is ready and counsel for the respondent seeks time on the ground that senior counsel is suffering from cold. And hence list this matter on 4/7 and not to seek any further adjournment in the next date of hearing. ಮುಗೀತಾ? ಹೌದಾ?
Yeah.